Item number 35, I move the approval to advertise the school board policy, new school board policy 3.17, recording of non-public meetings with employees of the school district.
Be approved for advertisement.
Approved to advertise,
Yep.
yes.
Second. Any discussion? Shirley Brown?
This is a difficult policy for me because I do understand how IEP meetings are confusing and difficult sometimes to remember everything that's being said. But our staff has taken steps to help educate the parents who have students even before they have to have an IEP meeting, and have given them resources that they can reach out to help. But I have been assured that agendas go out before an IEP meeting to parents. Agendas should go out. And I think the parents should have the agenda, and I believe that the parents should also reach out to who's ever calling the IEP meeting and propose those questions that they have and ask them to be answered and take notes at the meeting. I can understand why some of our staff are concerned about being recorded because we are in a gotcha environment right now. I know things that I have said get taken out of context and posted on social media. And we have staff that are concerned, on the one hand, that they might be taken out of context and posted on social media, but also that it might stifle open discussion in these IEP meetings. Another concern I would have is that the IEP meeting, the recording is then taken home and perhaps played where the student or the brothers or sisters might be able to hear it. And that might be a problem too. I'm sure that caring parents that are here would never do something like that. But we have others that I do believe would do something like that. And I don't think it would be good for any student, whether they were a part of that meeting or their name was brought up in the meeting, to then be put out there on social media. But I am concerned if the answer I need to have right now is, do we give an agenda before an IEP meeting so the parents know what to expect?
Sonia, can you come up, please?
Good evening. Yes, parents are notified and are invited to the school IEP meeting. So there's always notifications about the IEP meeting. Parents can submit topics of concern and discussion. And at the IEP meeting, they also can receive a draft of the IEP if they request that so prior to the meeting. This is for non-public school, and it does allow an exception for the parents to provide if they, for any reason, are asking for recording. We always take notes. Parents can also include their notes attached to the IEP. And for any reason that they might have difference of opinions about the conversations that took place, they can also invite anyone to the meeting and is accepted to be part of those conversations.
Dr. Asplund, perhaps you could answer this question, or maybe Sonia. How do other districts handle this? How many other districts record their meetings?
I don't know really how many other districts record their meetings. Again, I will tell you there's a couple of items on here that I can express. First of all, with NEFAC, the recording policy is new, and the policy was to address parents' use of smartphones and recordings of meetings and so forth. Amy Pitch, is she on the line?
Yes, sir, she is.
Yeah. Amy Pitch is our ESE attorney. I know she can speak to this as well. Sonia, if you could also let us know, I know with recordings, as long as everyone at the table is amenable to be recorded, we will record.
Correct.
Is that correct?
That is correct.
Yes. And how often is it that we do not record because not everyone is amenable to recording?
Well, our goal is always to have a collaborative conversation at the IEP meeting. And there are times that if an employee is not, because there's public loss for that employee, is not wanting to be recorded, then we try to mediate in terms of who are the required members to remain as part of the IEP, because the process cannot stop. And Amy's here and she can verify and clarify further in terms of we're looking about collaborative conversations about students designed for an education. So if an employee decides, no, I don't want to be recorded, then we try to have amicable mediation in terms who needs to remain in that meeting, but we cannot prevent from the process to move on. So parents always have a right to bring someone to the meeting, bring note takers, take notes, attach the notes as part of the IEP, which is a summary of that conversation. Mrs. Pitch, you're on the line?
Yes, I'm here. Good evening. Do you want me to speak to this a little bit?
Yes, please.
Sure. So I helped with the language of this policy, and it really does strike a balance between the rights of school board employees and the rights of parents. It also reflects the state of both federal and state law. There is no right to record in the state of Florida, but there are cases that basically say that if a parent has, a disability or an impairment or a language barrier that would make it hard for them to have full participation, meaningful participation, then that can be accommodated via an audio recording. So this policy is intended to strike a balance between those interests. And I will tell you that policies like this proliferate throughout the state of Florida. I can tell you that Miami-Dade has a similar policy, Orange County, St. Johns County. So a lot of large counties have similar policies because, again, this policy really does track what the law says about balancing the right to privacy against the right to meaningful participation. So that was the intent of this. And as Sonia said, there are many different ways that parents can ensure that they have meaningful participation outside of recording, such as taking their own notes, bringing note takers, asking to stop the meeting for clarification, asking to review notes at the end of the meeting, contributing items for agenda prior to the meeting, receiving drafts prior to the meeting. And Sarasota County is very good at doing these things. So that is the intent of this. It's certainly not to in any way squelch parents' rights to be meaningful participants. And I know that this issue did come before the Florida legislature, and they decided not to pass into law a statute that would require unfettered recording. And so at some future point, if they choose to do that, this policy could be changed. But at this point in time, that is not the right. And so we have this balancing act. And I think this policy does a good job of balancing those various interests.
So this policy does not say you can't record it. What the policy says is you can request that they be recorded. And if that request is denied, that the principal or that designee has to give the reasons in writing why it's being denied. I mean, so it's not saying a denial across the board. A parent can ask for it, and the notes can be made, and any notes that a parent makes can be added to the file.
Right.
Yes.
Thank you.
Karen Rose.
Thank you, Madam Chair. I will not be supporting this policy. I believe that I'm should say I'm very confident that the overwhelming majority of individual education plan meetings that occur in our district are quite successful. I hold myself accountable that every parent meeting for an individual education plan would have this opportunity to record, knowing that at least for the last 5 years, and currently that our students, our special needs students that are eligible to take the state assessment, which means that we're not talking about cognitively impaired students. The students that take that assessment, only 27% of those students are scoring at grade level reading, and we have not shown any improvement. I feel strongly that we should be going above and beyond in partnering with our families and looking at, this policy. And I think there's always a way to respect everyone's rights. And I speak from experience. I speak from 30 years of experience. There's always a way to go above and beyond, support our families, and in particular, support our students with special needs. So I will not support this policy as it stands.
Bridget Ziegler.
Thank you, Madam Chair. If I may address a question to Mrs. Pitch, if she's still on the line, or does she go? She gone?
I'm here.
Oh, thank you so much. You had mentioned this reflects state and federal law. Is that correct?
Yeah. Yes.
Is it not true that federal and state law are silent on this matter?
No, actually, there are decisions from the Florida Division of Administrative Hearings that speak specifically to the issue of recording of IEP meetings, and they state that there is no right to record on the part of the board or the parents.
And where is that?
It's the Jackson case. I can provide that citation after the fact if you'd like
No,
it.
actually, I read it. I think, okay. So thank you for that clarification. And I think there are two issues at that one that I had read through, and Dr. Aspen and I spoke about that. But I'm going to move to Sarasota County specifically, and I know that that the district has had a long history of accommodating the request of parents for recording. And as Mrs. Rose eloquently stated that, and I agree with that, I have substantial faith in our staff and the role of which they want to find the best remedy. I also come at this as a parent, having had sat through some of these meetings, and I cannot diminish how, while you have the most impassioned, thoughtful people in that room, you have 10 plus people in that room, and it is your child, and you're talking about jargon that is the first time coming at you in a number of ways. And I mean, we have people come here on all different issues, speak about their children, and you can see them get emotional. And I think you have to put your mind into that framework when you're thinking about a 504 and IEP meeting. If at a public meeting someone, and even very positive discussion, has a hard time and gets choked up, it's because that's what happens when you're talking about issues with your children. And I mean this in the perfect setting where everyone is on board trying to work through it. It is emotional, and a lot of things are coming at you, and it is not a gotcha, but it is intended to balance the scales and ensure a win-win, as was stated before. I am, it's no secret, I have certainly worked at this at the state level. I will continue to work at this at the state level, but as I sit on this board, I would like us to be the leader and not defer to see what Tallahassee does. I would like us to lead with the aspect that we've always done for 20 plus years. And when I hear from people in the community, again, this is similar to the public comment, where there are a number of people who on certain issues oftentimes find themselves opposite of it. This one is one where it's very unified and want to support, and it comes down to, it doesn't matter what the issue is, it is balancing the scales for a win-win. I regret that it's been utilized as a inferred that it's being done in a tactic as a gotcha. I reject that, and I don't think that that's at all where it is. And wherever that's come from, I want to think about the harm that this can provide to families just being able to advocate for their children. I want to remind everyone here, and again, I'm taking this in the most positive aspect, that we have well-intended, very knowledgeable people. We have the money, the resources, the time, and it's not your child where it, and I know we look at all our children, but you have to understand those scales and what a disadvantage and what a message that sends to a family for whatever reason to record. I'm actually going to make an amendment, and I move to strike all below item under strike exceptions and leave it as the school board is committed to providing parental legal guardians with the opportunity to meaningfully participate in the process of identifying, evaluating, and programming for students with disabilities. Therefore, audio recordings defined as using any device or object to record voices and sounds that may be reproduced or reviewed may be allowed when a parent or legal guardian provide a written request within 3 days prior to the scheduled meeting for an IEP or a 504. That is my motion.
And I second that motion.
Point of order.
Yes, Mrs.
We've discussed before changing the language of a policy without having something written in front of us. And so if we want to go forward with this, I would recommend that we get what your language is in writing so we can look at the two of them and make a decision. Or perhaps what we need to do is pull the item and move it to next work session or the next meeting.
Well-
because I'm not prepared to vote on something I can't see and read. And I'm sorry, but she talks real fast, and I have a hearing issue. I don't know what she said.
I can go slower if you'd like.
No, I think you've gone well into what you think, Mrs. Ziegler. So you've got a motion and a second. Is there any other discussion?
Can I address her comments?
We're discussing the motion.
Oh, okay.
Okay. Shall we take a voice vote?
Well, I was going to speak to the motion too. I think the motion is out of order because we've discussed not doing these types of things
Yes.
at the board meeting before, and also while we are here representing parents and students, we are also here representing staff. And we heard from a staff member earlier today about staff feeling they're being attacked.
Yes.
And so I'm here. I'm supporting staff too in this. And I heard that staff, if they want to record, we'll work with them on that. And so I'm prepared to vote on the.
Tom Edwards had a question for the original motion. Do we go back to Tom, or do we finish out this and then go back?
If there's no more debate on the motion that's pending, I would suggest that you dispose of the motion that's pending. You have a motion that's been properly
Yes.
moved and seconded
So-
and discussed.
Amy?
Oh, sorry.
Amendment.
Attorney Pitch, I'm sorry.
Yeah, I'm here.
Do you have something that you would like to say on this amendment to the motion?
Yes. So, I've been an attorney for 22 years, and 16 of those years I've spent sitting in IEP meetings pretty much almost every day of the week. So I've been to hundreds and hundreds and hundreds. And I will tell you that recordings do have a chilling effect on collaboration. I have noticed, especially with the advent of social media, that employees are less willing to share their honest opinions. And a lot of times they will tell me or administrators behind the scenes, but they're afraid to voice them in meetings. And part of that is because, and I have seen this, sometimes parents do excerpt recordings and put them on social media without context. And that can be very damaging to the employee who has no ability pursuant to FERPA to clear the air. So they are muzzled. So there are some concerns. And I will tell you too, as somebody who defends you all in hearings, I've never had a parent bring one of these recordings to a hearing, but I have had parents, a few, utilize them on social media to try to hurt employees that they're angry at. And I think that that's a rare occurrence, but it does happen. And I have seen this chilling effect. And I will tell you that other attorneys who do what I do, we talk to each other and we see it too. So this policy is intended to strike a balance between that chilling effect and those privacy rights, and then also the rights of parents who have needs that would make recording important for their meaningful participation. And that's why it's been drafted in this manner.
Thank you. Do we have any other thoughts or comments on this amendment to the motion? Hearing none, let's take a voice vote. All those in favor, please say aye.
Aye.
All those opposed, please say nay.
No.
Nay. So the motion fails 3-2 with Mrs. Ziegler and Mrs. Rose voting yay, and Tom Edwards, Shirley Brown, and Jane Goodwin voting nay. Let's go back to the original motion. Mr. Edwards, you have discussion.
So I think there's a big misnomer that only a couple of board members are interested in parent rights. And I need to just, before I comment on that policy, say how absolutely unfounded and untrue that is. There is no better student outcome ever that a parent and a student and a teacher and their principal are 100% involved in that student's outcome. And there's no better education when that happens. So, and that's what I believe in, and I need to say that for the record. There are parents who are in this room who think that I'm making that up, but that is my belief. So when I look at an IEP meeting, and when we had these discussions, I would say almost a year ago, and it was, I think Mrs. Ziegler brought up a discussion about policy and recordings because she wanted to know what the policy was for that particular, and we had much discussion. And I remember hearing from an educator that when a parent requests the recording out of anger, stop that IEP immediately and go back to the beginning and start over, because that reduces the collaboration, that reduces the outcome for that student to be of its highest value. And I took that to great heart. And I went back in, and Dr. Asplin knows this, and I spoke to all and everyone concerned to find better ways to improve those IEP meetings, better ways. And so so in my mind, right now, there's a policy that allows for all IEP. If they ask for it, they have an opportunity to get it. And I have yet to hear that it was denied. I've yet to hear that when it's asked to, so we're once again passing a policy to create a solution for a problem that doesn't exist. And that's my frustration, from the laws of Tallahassee to the conversation that goes right down to this policy. You're asking me to vote on putting something into place to solve a problem that does not exist in our school district. When a parent asks for it because another parent can't attend the meeting and they want it recorded, it gets recorded. When a parent requests because it's a language barrier, it gets recorded. And I have yet to hear of any denial. And when there's a disagreement, they do, in fact, start over and try to find resolution and make sure that everybody walks out of that room or out of that meeting with satisfaction. And that's the point. And so that's the frustrating part here, is that we do believe in what's in the best interest of the student, and we do want the parents to be involved, and their rights are essential for the highest level of student outcome. And that's why I'm supporting this policy.
Shirley Brown.
I had unclicked my request because Mr. Edwards said what I would have wanted to say.
Well, he said it all, didn't he? He said everything that I think as well. So if there is no other discussion, please vote. And the motion carries 3-2 with Mrs. Ziegler and Mrs. Rose voting nay.